Florida's new law signed by Republican Governor Ron DeSantis establishes one of the nation's strictest social media bans for minors, pending expected legal challenges. Effective January 1st, the law prohibits social media accounts for children under 14 and mandates parental consent for 15 and 16-year-olds. The legislation pushed by Republican Speaker Paul Renner addresses concerns about minors' vulnerability to addictive technologies. While a previous proposal was vetoed by DeSantis, a compromise was reached to accommodate his worries. Despite anticipated lawsuits, supporters believe the law, which focuses on restricting addictive features rather than content, will withstand legal scrutiny. However, critics argue that the measure encroaches on parental rights and may be unconstitutional.
We appreciate all the speakers, and I would just say and the speaker mentioned it, and the Attorney General mentioned it, but the way this bill is structured, it is not engaging in any regulation of speech. It is basically identifying functionality, that is causing harms, the addictive features. And so that's laid out in the bill. We worked hard with the legislature because at the end of the day, we're not just here spinning our wheels. We're not just trying to get a photo. We want something that actually sticks and actually has a positive impact. And so there was a lot of work that was done to ensure that. And I think we did it not only look, anytime I see a bill, if I don't think it's constitutional, I veto it. But my view is not always the same as courts. So there are things that I think are plainly constitutional that some courts, may have issues. So we not only satisfied me, but we also satisfied, I think, a fair application of the law and Constitution will mean that this bill is able to do. But we've had challenges. I mean, we were the first state to offer protections for citizens in Florida against being unfairly censored by these big tech companies because they're advertised as being open platforms. You join, they monetize, they get your data and they monetize it, but then you say certain things that they don't like. Maybe you were against COVID lockdowns, maybe you were saying something that there's not 67 genders, all this, and then they may marginalize you or suspend you or do all this stuff. And that was being done religiously, and it was all in one direction. Meanwhile, these companies get liability protection from the federal government. So they're not liable for what goes on in their platform. They claim they're not publishers, but yet when they act like publishers to essentially silence one perspective, that's a huge problem, especially when all this is done. And so, we did a legislation that basically just said someone that's in that situation, if they're unfairly targeted and they're censored or they're deplatformed unfairly, then they have an ability to bring basically a consumer fraud action. So it's not the government necessarily doing it, it's a private citizen. And that went all the way up to the Supreme Court. Texas had a similar law. And, they haven't ruled on it yet. They had an oral argument. And you can't always divine from that, but I would say that while we may be in good shape to win on procedure, I still think that there's a lot of judges out there on the Supreme Court and below that are basically like, well, corporations, just you can't do anything to kind of structure this, that it's not the same. But this is basically a major public forum now when you have these big social media companies, and they're subsidized by the government with this liability protection. So the idea that they should be able to have their cake and eat it too, act as publishers and yet get liability protection because they're not publishers, that doesn't work. Nevertheless, I think it's going to be a challenge. We'll see how that shakes out. And then the other thing that we ran into, we passed legislation called the Stop Woke Act. And basically what it says, there's different provisions, but for private workers at private companies, we basically just said, look, you have a right as an employee in Florida to opt out of this woke training. You don't have to sit there and self-flagellate yourself because you happen to be white, let's say. Company can say whatever it wants, the company can offer whatever training it wants, but you have a right to opt out. And that was, we lost in court with Republican judges saying that somehow that violated the company's First Amendment right. But they can say whatever they want. We're just saying you have a right to opt out of that you shouldn't have to be a guinea pig and let them shove this down your throat. So, and I just think it's a fundamental misunderstanding of what's going on in society to basically say that companies have a First Amendment right to coerce employees into woke indoctrination. That's not healthy for society. So we're going to work on ways to be able to protect our employees here in the state of Florida, but I just think it's fundamentally wrong. And it's one thing to say a company can't be woke. We're not saying that. We're just saying that employees should be able to opt out. So there's a lot of just moving parts in some of these things. I think this did as good a job as you can do, not just to say, here's what we think is constitutional in our own judgment, but also what we think would ultimately be able to land given how some judges have gone crosswise on some of these issues. So I think that's to be commended, and I know there was a lot of work that was done. There was a previous version. We had to go back and forth a little bit, but I think this one is in a good spot. So if you guys are ready, we'll go ahead and we'll get it done. So, the speaker, you want? All right, who else wants the other no, I'm going to do it. Okay, all right, now, any young kids? Anyone want one?
Momsies are not permanent.
These are not permanent. Okay, they'll wash off. Okay, you want one? All right, I got one more. All right, it's done. There you go.